Hi, my name is Michael Burgess. I'm the managing attorney of MB&A. I'm a certified legal specialist in California workers' compensation, and I'm a trial attorney. I wanted to take this video to address some recent case law, and the particular case I want to discuss now is a case called Benson versus Workers' Comp Appeal Board. This is a very, very big case. It's an older case, but it's the seminal case law regarding apportionment amongst multiple dates of injury. Prior to the change in law in what's called Senate Bill 899 in 2005, prior to 2005 and that Senate bill, there was a case called Wilkinson. And what essentially the case law was is as follows. It didn't matter if you had 1 injury or 10 injuries. As long as those injuries, as long as the injured worker reached maximum medical improvement or was permanent stationary at the same time, all those injuries added up and it wasn't an issue. So your ultimate disability didn't matter if it was attributed to 1 injury or multiple injuries because it was all work related, right? And you were able to get accurate and adequate compensation. Then the law changed in 2005 with Senate Bill 899. And then we had a whole new realm of apportionment. And there's a case called Escobedo that addresses that apportionment is through causation of disability. So then the case of Benson came down and basically said, it basically overturned Wilkinson and said, no, it doesn't matter if they all became PNS or reached maximum medical improvement at the same time. That doctor needs to try to parcel out the disability attributed to each of those dates of injury. Now, what most of the viewers or anybody who's not a practicing attorney in this field is going to not understand is, what does it matter? If they're all industrial injuries, what does it matter? Let me tell you how significant this case is, and we're going to go over some real-world numbers here. Quick, easy example. If an injured worker is found to have 20% disability, and the doctor says, it's attributed to 1 date of injury. Now, this is a quick little money chart here that breaks down, and the money is statutorily set. So, I don't control that. An attorney doesn't control it. It's set by the state. Really, an attorney who's advocating for their client is trying to get them the highest they can on this chart to get them the most disability award and their proper benefits. But a 20% disability award is payments of currently from 2014 to the present is based upon payments of $290 per week. The greater your disability, the longer the duration of those payments. But a 20% disability rating is 75.5 weeks of these payments, totaling a little over $21,000. Okay, in this case, $21,895. Not very significant money considering, potential significant disability. But now, let's say that the injured worker had 2 injuries. And the doctor says, well, yes, 20% disability overall, but it's split equally 50-50. So what that essentially means for this injured worker's case and their compensation is they don't get 1 20% award, they get 2 10% awards. And guess what? A 10% award is 30 weeks, 30.25 weeks, totaling $8,772.50. Now, let's look at, and I did some quick math here, and that means the overall difference between 120% and 2 10s is the difference between $21,895 and $17,545. So essentially, just by bifurcating the disability into 2 separate awards, that injured worker just lost 20% of their compensation. Now, that's at 20% disability. Look at it at 60% disability. 60% disability is $101,862.50 in total overall compensation. But if you separate that out into 2 30% disability awards, each 30% disability award is $37,990. That means it's a difference between $101,862.50 and $75,980. That's roughly a 25% loss. So we lost another 5% of benefits. But guys, once you're above 70% disability, it's much more significant. And there's a huge difference between 99% disability and 100% disability. Let me tell you how catastrophic this is, okay? A 100% disability is 2/3 of that salary for the rest of their life. Take a younger, fairly decent wage earner, that's going to be about $2 million. It could even be much more, okay? Now, 2 50% disabilities for that same person who would be entitled to $2 million, that's $78,662 for the 50% disability. Times that by 2, it's $157,000 and change. Guys, that is a 90% loss on your compensation because even though they're all industrial, some doctor partitioned that disability. Benson apportionment is bullshit. It is straight up bullshit. It's not fair. It's not just. I think it's terribly inadequate. I don't believe it's constitutional because California Constitution, Article 14, Section 4, really sets up this system that's supposed to provide substantial justice. This isn't substantial justice to me. But my opinions regarding the constitutionality of this case doesn't matter. It's the law. It's binding. It's the law we have, and so we need to navigate with the current existing law. So Benson apportionment does have some exceptions, and the exception is the phrase inextricably intertwined. Now, and remember that apportionment, including Benson apportionment, is the defendant's burden. That means the defendant, the employer, their insurer, the attorney that's representing them, it's their burden to show that there is valid Benson apportionment. And it is my job as the attorney to advocate for my client and show that the defendant can't meet that burden to a reasonable degree of medical probability. And you know what, to be blunt, it's not an easy burden for a defendant to sustain. But without an attorney or a sharp applicant advocating for themselves, they get bullied, and the doctors are giving bullshit apportionment left and right. So you need an attorney to, one, depose that doctor, send an interrogatory to that doctor, and get them to change their opinion. Or show that those injuries are, quote unquote, inextricably intertwined, such that a defendant can't satisfy their burden to a reasonable degree of medical probability because it is inherently speculative. All these words I'm using are key words and key terms that need to be established, and the record needs to articulate this stuff in order to get substantial justice for the injured worker. Now, if a doctor is saying, okay, yes, there's overlapping body parts, I can't parcel that out to a reasonable degree of medical probability, it's inextricably intertwined, now the injured worker can go into court and get a joint award, a single award from one date of injury, and not get screwed by this case, Benson, and not get Benson apportionment, and really get their proper, adequate settlement that was the law prior to 2005 based on the Wilkinson case. But this case, Benson, is a horrible case for injured workers. But there's some silver lining here because there are exceptions, and a smart attorney who's done the due diligence and established a clear record that can point out that the defendant can't sustain their burden can potentially get substantial justice for their client. So this case is Benson versus Workers' Comp Appeal Board. It's a horrible case. It's a binding case, but there is some way to get around this case. I strongly suggest that if you're an injured worker and you have multiple dates of injury, whether it be multiple specific injuries or a cumulative trauma, separate periods of cumulative traumas, or a cumulative trauma with separate specific injuries, if you have multiple injuries, you need an attorney to help fight this case of Benson apportionment. I hope that this has been helpful and educational. If you're watching this, if you have any questions or concerns, please feel free to give us a call. We have the answers, and we're here standing by. Thank you.